Good afternoon, everybody, and welcome to this afternoon's webinar about CRICOS Compliance. Thank you very much for coming along, and thank you to our presenter, Ian Eyre from International Education Initiatives. Ian's been working in the international education sector for over 20 years, and he currently runs a consulting business, International Education Initiatives, which supports CRICOS and VET colleges in a range of different areas, and especially in compliance. So thank you very much for coming along today,
Ian. Thank you, Sophie, and thank you everyone for attending. I think we're still getting a few people logging in, but I'm going to kick off because there's quite a lot to cover, and I'm sure you've got busy schedules to get back to. I think I just need to click over there for a second. So yeah, as Sophie mentioned, I'm going to be talking to you today about CRICOS compliance. Just to give you a quick bit of background on me, as Sophie said, I've been in the sector for a long, long time, predominantly in CRICOS, but also across the sector. Quite a few years ago, 4 years ago now, I launched a consulting business, International Education Initiatives, coming out of running colleges and working in colleges. Back when I was running colleges, one of the last things that I dealt with as general manager of a large college that was across a couple of states and in CRICOS and VET, was dealing with compliance. We needed a complete update and review of our compliance, and we didn't really have any internal resource in terms of a compliance person to take care of it. And so, I started off, trying to get people to do it. And, internally, no one really wanted it. They were all very, very busy doing other things, and it wasn't really on anyone's wish list. And so I looked outside for consultants and spent about 9 months trying to find, recruit consultants. I went through hiring and firing 3 of them and had no end of difficulty. And one of the things I found problematic was that, one could do a little bit of something and not a lot of other things. And there were so many things that you ended up having to juggle lots and lots of people. It was quite a painful and difficult process, and in the end I had to do everything myself, and at the end of that decided I never wanted anything to do with compliance again. So when I started my consulting operation, it was very much focused on growth and profit for colleges, on acquisitions and exits and so on, and it took me 3 years before I was ready to get back into looking at compliance, because that was something that colleges were constantly talking to me about, saying, can you help us with compliance? Can you connect us with people to fix our compliance? And asking lots of compliance related questions. And so over the last 18 months, it's been a key focus and fast becoming the focus of my organisation. And so over that time, I've done a score of different audits of colleges, helped many go through re-registration, helped many update and so on, and helped a few with more serious compliance issues where they were facing difficulty with the regulator. And what I've noticed is that there are a core set of issues that people face, and so I want to cover those today and see if I can't help colleges and help you guys running colleges get a better handle on what's involved and some of the key issues and problems and so on that people face. So just to jump straight in, starting off with some high-level questions, and then we'll dig down as we go. What is compliance? Really, it's following the rules. There are a set of rules that we have to play by. If we follow them, then we have order. If we don't, then we have chaos. From government's perspective, chaos is bad. From provider perspective, chaos is bad, and definitely from student perspective, chaos is bad. So compliance is really around, in some ways, protecting all three of those groups: colleges, but more importantly, students, and to some extent, more importantly, it's protecting the $37 billion that international education generates for the country. It's a very important part of the Australian economy, and the government, as part of their governance, needs to ensure that they're protecting that and making sure it's sustainable and an ethical sector. So who makes the rules that we comply with? Well, they all come out of government, basically. Department of Education is a key architect, for want of a better word, for a lot of the things that we think of when we think about compliance in education. Immigration is another key department. But there's also, we've got to remember that we are organisations, businesses, whether private or public, and we also have to comply with rules that are developed by trade and investment, by Department of Industry, and so on. So there's quite a broad range of departments involved, and there are a bigger number of stakeholders that influence those departments as well. Who enforces the rules? Obviously we're all familiar with ASQA and TEXA as the regulators for the sector in terms of the ESOS framework, CRICOS and so on. But we also have to remember that as organisations, as I just mentioned, we're also regulated by the ATO for tax and super and so on, by ASIC for business registration, corporate compliance, by the ACCC for consumer regulations, and so on and so forth. So there's quite a few different ones, but the main ones that we think about are ASQA and TEXA. Now, I'm told that normal people don't ask this question, but whenever I see a set of rules, I want to know, why should I comply? Why should I do it? What happens if I don't? And so, I think it's an important thing to think about and consider. And there's a whole range of reasons why we should, not least of which is the punishments for not doing so. And they can vary from a rush to fix things because you're given orders to have things fixed by the regulator, and they give you 2 weeks, 20 days, whatever it might be, to sort things out, and that can create quite a bit of pain. There can also be conditions put on your registration, and they can go to the extent of stopping you from recruiting any new students on international student visas. And it can go to the extent of registration cancellation. And looking just at ASQA, over the last 3 years, they have cancelled more than 600 registrations. Majority of those were in the vocational sector, but there were a few in the CRICOS sector as well. And look, while many people say they got the dodgy ones, and to some extent, many of those providers weren't necessarily the best providers around. But there are also quite a few who were delivering, good services, had happy students, looked after their students and so on, but still did not meet the minimums of compliance and were cancelled. It also doesn't account for the many colleges who were unable to manage the financial burden of conditions on their registration and so on, and so closed of questionability of their own volition. But there are very serious consequences for not complying, so it's obviously a fundamental thing that organisations have to do. So the next question is what are we really talking about? And it really is quite a maze. In fact, the more time I spend in this area, the more I realize that it's quite amazing. As I turn corners, I find new little surprises in terms of instruments, and I use that term to refer to a piece of legislation or regulation, you know, often I get asked, you know, how many are there, or what are they all? There are quite a lot, to be honest, and I'm still discovering new ones that cover little bits and pieces here and there. But the main ones, I think most people are familiar with. You know, there's the ESOS Act, of course, and that's the overarching piece of legislation that gives context to everything, sets who the regulators are, and puts the definitions in place of, you know, what is a provider, what is a principal executive officer, and so on. It also has a few specifics in terms of obligations of providers. So it's definitely worth reading, although I think it's probably not read very often. The National Code is one that most people are familiar with, covers a lot of operational requirements for all providers, whether they're vocational, higher ed, or ELICOS. Of course, the ELICOS standards, specifics about ELICOS. I think most people are fairly familiar with that. And for most people, that's kind of where it ends. But there's quite a few more to look at. There's the ESOS regulations. That's probably a bit better known today because there was quite a bit of publicity around the update at the end of last year. But that sets out a lot of specific details around information requirements. So what information providers must record, must communicate to students, to regulators, and so on. So that's a really important one to look at. There's also the specifications around calculating refunds. That one, I think, well, I'm quite sure is not well known. I'm quite sure because I see lots of refund policies that are not compliant with it. And I'll talk a bit more about that one a bit later on, but that's an important one to check out if you haven't. Then there's a whole bunch of other little bits and pieces that come with quite a bit of burden. The financial viability risk assessment requirements, for example, that's quite an onerous one. Takes quite a lot of time and is quite tricky. It's also not mentioned anywhere. It's covered under the Better Act. It's covered under the RTO standards, or the standards for RTOs. It's not covered under the ELICOS standards or the National Code. However, ELICOS providers do have to comply with it, and we'll come to why a little bit later on. There's other ones like the agency determination, which sets out which of the regulators you're under, TEXA or ASQA. And then, you know, you've got the things to do with student visas. So you've got the migration regulations, and you've got the amendment around overseas students. You know, so we're already getting to quite a few, but it keeps going. There's the fit and proper persons requirements that sets out who needs to complete the fit and proper persons. Looking at the lineup of people who are on the webinar at the moment, most of you should have completed one. Teachers know, but directors of studies probably do. There's also, you know, a few general managers. They all should definitely have done it. So, you know, it's certainly one to have a look at. Work with children checks if you've got under 18s. And then, you know, if you're like the majority of ELICOS providers, at least in the private sector, you probably also do VET. So there's a whole range of other requirements. So there's quite a few. If you're in the higher ed space with a university, then, you know, There may be elements in your organisation that you're across in terms of higher ed standards, the threshold standards, and so on. So it's quite a lot, right? But there's also the fact that you're part of an organisation, so it just gets bigger and bigger. You've got business registration requirements, which are, initial, but then ongoing and annual. There's corporations law, and that's an absolute monster. There's tax law. There's fair trading and consumer protection law, and these ones often just get forgotten. There's contract law, so contracts with agents, contracts with students. You've got a written agreement with each student. There's also contracts with staff and suppliers and so on. There's privacy law, international as well as Australian. So you've got the Privacy Act of '88, but you've also got the GDPR regulations. And these really might seem esoteric or irrelevant, but I see that there's a bunch of people here to do with admissions and marketing. There's also teachers. We're all taking student names. We're all taking details of students, contact details. So where you've got European students, you're now required to comply with the European privacy laws as well. And just because you're an Australian organisation doesn't make you exempt by any means. So it's quite a bit here. Anti-bullying and anti-discrimination, employee law, WHS, there's some pretty serious stuff here. There's also the Building Code of Australia. It's very specific requirements because you're all education organisations, so you've got to be 9B compliant. Very specific requirements there. And that sort of then rolls over into local council regulations. So compliance goes well beyond just the ESOS framework of instruments, and it's certainly important that organisations are across all of these areas and conscious of them, because they do interact quite a lot. But look, just ignoring that last slide and ignoring all of those general business compliance issues, if we think about the number of rules, if you're in ELICOS and only in ELICOS, and you went through and were sort of somewhat deranged and actually counted them up, I don't know who would be so deranged, maybe me. There's over 600 rules just for ELICOS, and if you're doing Vet 2, there's over 800. So it's a pretty massive number of individual rules to be dealing with. And the question is, why is this a problem? The reason it's a problem is that it's no one's favorite. It's not anyone's priority a lot of the time. It's no one's why, to steal a term from Simon Sinek. It's not the reason most people got into the business. It's certainly not their passion most of the time. And it's just too complicated. And frankly, it's kind of just too dull. I know that was certainly my attitude when I was running colleges or working in them. It was more than anything, it was an obstacle to get around, and to try and minimize the time spent. And obviously that detracts from how effectively you pursue the work involved in it. And if all that's not difficult enough, the rules change. In 2018, we saw a complete change across the board with the ESOS Act, the regulations, the national code, the ELICOS standards. End of last year, we saw, or through last year, we saw a number of other changes. So these changes come fairly regularly. I mean, the 2018 changes across the board, tend to happen once every 10 years or so, but there are fairly constant changes as well. So that just adds to the level of complexity in this space. And when we face complexity, the human brain deals with it in very particular ways. One of them is kind of ironically depicted by this, where you know, we see that, you know, is it the right side? I can never remember this. The right side of the brain deals with color and art and so on, and the left side deals with maths. It might be the other way around. I can't remember. But it's obviously absolute nonsense. The brain is far more complicated than that. It's not simply divided down the middle. But dividing it down the middle and saying right and left brain for this and that just makes it easier to talk about. It makes it easier to communicate, and it makes it manageable. And so that's what we tend to do. We tend to really simplify. And this is one of the key issues that I see with colleges in dealing with compliance, is that there's a simplification process, because these 600, 800 rules is just too much. And that plays out in terms of looking at what, to start with, is easily measured. And if we think about what's easily measured, what's easily measured is attendance. Attendance needs to be, you know, above that minimum of 80%. So it's an easily measured figure. It's a number that we can apply to all our students. Another one is the 1 to 18 ratio. Are there 18 or fewer students in each class? That's an easily measured thing. You know, are our students attending 20 hours or are our courses 20 hours per week? TPS is another one. If students are doing more than 25 weeks, are they invoices for 50% or less of the fees? You know, these are easily measured, and so, you know, we tend to look at these ones. There's also what's easy to look for, and again, you know, we can think about those things as, you know, teacher qualifications. These are easy to look for. A teacher staff room, it's a place you can find in the college, so it's something that's definitely easy to look for. Curriculum documentation, you know, accurate marketing. These are relatively easy ones. Do we just have the courses that we've registered to deliver, for example? You know, all of these are easy to look at, and so they tend to be the main things that we think about. And they direct our attention, you know, and, you know, fundamentally, what I see most of the time in colleges is that they start off with this question here when they're looking at compliance, which is, how do we show that we're compliant? Now, how do we show that we're compliant? Well, we look at those things that are easy to measure and that are easy to look at, and we then ask ourselves further questions, such as, you know, do we ask the students their addresses? Do we tell the students the rules? Do we keep to 18 students per teacher? Are we recording attendance? And do our teachers have a degree in CELTA? And these simple yes/no questions, you know, break it down and make us feel like we're you know, covering our compliance. Problem is that we then do this process whereby we answer these questions, we're satisfied with the answers, and then we just extrapolate from that therefore we must be compliant. And it comes down to this principle from Daniel Kahneman, the author, Nobel Prize winner, Thinking Fast and Slow. If you haven't read that, definitely read it. But he has this principle called Viability, what you see is all there is. And it's just basically that we look for a bunch of things that are easy to measure, that are easy to find, that fit our beliefs, and then we extrapolate out from that. So we answer these questions, and then we go, well, we must be compliant. And I see this all the time, and, you know, it creates a lot of problems where colleges have to scrabble around to try and fix all the things that they've missed. So what I want to suggest is that there are a core set of questions that we should be asking that can really help us avoid these problems. And the first and probably the most fundamental one is how are we non-compliant? And asking that question sort of drives us to keep looking until we find stuff and not be satisfied with the easy answers, to keep looking until we find stuff. A little bit of a problem though is when we find a couple of things, we tend to be satisfied when we fix them, that therefore we're compliant. So the next question is, what requirements have we missed? And that drives you to keep looking through the requirements, keep working your way down through the national code and ticking off each thing, and checklists definitely should be the foundation of your efforts towards compliance. Another really common issue I see is providers and people in general. They hear the rule and they interpret the rule. And interpreting rules is what courts and lawyers and governments do all the time. And the 2018 changes certainly made a lot of the requirements kind of high level would be one way of putting it, ambiguous would be another, but they certainly are open to different understandings. And so what I'd recommend here is that it's really worthwhile for people to take some time and to look at requirements that could be interpreted in different ways, write down their own interpretation, and then check in with others who have written down in their organization, who've written down their interpretation. Just make sure that you're seeing things in the right way. We'll come back to this issue later on, but then this can be something that you can take to community forums in the sector, forums organised by English Australia, for example, and discuss with with staff from other colleges how they interpret certain rules. That can be a very helpful process in making sure that you have actually understood things well. And finally, another key question is, how clear is our evidence? So, the regulators are quite switched on now to the issue around colleges having great policies and procedures that aren't ever read or implemented, and so they really are looking for evidence that you're compliant. So, making sure that you have clear evidence that not only do you understand the rule, but you've followed the rule. Now, another really key issue comes down to who's managing compliance. Now, what I've seen over my time is that the vast majority of cases where colleges have a compliance resource tends to be one of two people in 80% of the 80% of the time. It's the head of the academic department or the head of the admissions department who kind of gets lumped with managing compliance. The problem there is that, as I said earlier, it's not their why, it's not their priority, and their day tends to involve, solid chunk of time spent on email, their standard work, a bunch of meetings about their standard work, some more email, some urgent projects that they've got to rush through, a bit more standard stuff, and then wedged in it right at the end, if there's time, it's a little bit of time on compliance. And so it really is the afterthought, and that can lead to things getting missed. The other issue with this approach is that, no offense intended to those people who get stuck with the compliance from their academic work or from their admissions work, is that academic people are fundamentally academic people and admissions people are fundamentally admissions people, and they tend to be expert in their areas and really focused on their areas and less focused on the other areas. The academic managers don't tend to be fully across all the things that are happening in admissions or in marketing or in finance, and likewise for admissions. And so those things get less attention, and the person managing compliance tends to focus primarily on their area. And as we've seen earlier, compliance covers everything from your building to your contracts with agents to your course documentation. So it really does cross all the boundaries. The 20%, and maybe it's a bit less, will have a dedicated compliance person. But the problem there is that compliance person, at least most of the ones I've met, tend to not be experienced in the academic teams or in the admissions teams or in the marketing teams. They tend to be a compliance person, which means that while they're really good at understanding the rules and requirements, they tend to not know where the bodies are buried, for want of a better expression. So they miss evidence that compliance is internal compliance rules, policies and procedures are not strictly being followed. And this gets worse with bigger organizations where they're more spread through multiple campuses or very large departments. And so, you know, compliance problems occur because things are getting missed. And so what I'm going to do now is work through a few of those common areas where I've seen lots of compliance areas being missed. Pre-enrollment and pre-commencement information is a really common one. There's a shopping list of things that need to be in these documents, and you know, you've got to read the ESOS Act, the National Code, ESOS regulations closely, and get yourself a checklist. Something that I have found very, very helpful with clients is a marketing collateral checklist that, you know, you've got to tick off that you've included each element. So I'd really encourage people involved to have a checklist to make sure that they are getting everything, because this is one that I see all the time. Little bits get left out. They're not in the written agreement, but they're in something else, and you know, the student doesn't get it until the orientation session, which is no longer pre-commencement or pre-enrollment. So, you know, it's not strictly speaking compliant. So that's the first one that I see as problematic. Part of that, I guess, and really overlapping there is the marketing and student recruitment collateral. Again and again, I see colleges where they haven't updated it in quite a while, and it'll have references to DEC, for example, instead of DHA. It's not a big deal that they refer to DEC, but it is a red flag to a regulator who looks and sees DEC and then thinks, well, they haven't updated this in a while, or they're really not aware of who they need to be compliant with. And so that triggers them to look very closely at everything else. And it's a very short trip to find other things that haven't been updated too. So, you know, making sure those things are regularly updated, and that should happen at least annually to review terms and conditions of enrollment and you know, application forms, agreements, and so on. Agent contracts is another one, because they're often done within the marketing department, and marketing departments tend to be the least interested in reading through the National Code, for example. You know, they're very often not up to date with the latest changes in the requirements in 2018. There are a whole range of very specific things that colleges have to have in their written agreement with an agent. They have to have a written agreement with every agent who is recruiting for them. You know, so this is one that I see quite problematic. It's also one of the ones I see that sort of steps outside the ESOS compliance into other areas of compliance. I've seen quite a few agent contracts which would have raised an eyebrow with the ACCC, you know, saying things along the lines of, you know, you can't telling agents that they can't discount fees. Obviously, that, you know, is infringing on some of the competition, anti-competition rules, resale price maintenance, and so on. And so that's one to really be wary of, and you know, colleges should be making sure that they have a lawyer review their contracts so that they're both legally binding and also legally compliant. But they also need to make sure that that lawyer is fully across requirements of the ESOS Act, the National Code, and the ESOS regulations, which have, you know, things that are required in those contracts. Agent training, you know, the changes in 2018 set out a whole set of obligations on the provider to manage their agents and make sure their agents are well informed and acting in compliance, even though the Australian regulators don't regulate the agents. They regulate the providers, and the providers are employing the agents. And so colleges need to be training their agents and see that happening very rarely. Agent registrations is another really common one, especially for CRICOS providers. Most vet providers are aware that they need to register their agents, not just in prisons, as was raised last year, but they also need to register their agents directly with ASQA if they're regulated by ASQA. It used to be on the ASQA website, now it's in ASQA.net. So if your marketing department or you're from the marketing department, that's something to check that you have done, that all of your agents are registered in ASQA.net. That's one to be really cautious of. ASQA themselves have flagged the fact that CRICOS colleges often miss this one, and it's an easy one to miss. Other ones that are often missed, and these ones always surprise me, but because they're these ones that are easily measured, but attendance reporting in terms of the timing, so when to report a student is a commonly missed one, and overlapping in here is the compelling and compassionate clauses with an exemption from reporting a student. I very often see when I look at these cases that there is no genuine evidence. There'll be a couple of doctor's certificates that'll not, that'll cover a week of time when a student's on 72% attendance over 50 weeks, and it's just not relevant to why they're below 80. Or the other day I saw one where there was a doctor's certificate that was really highly questionable, and I think a reasonable person would have looked at it and said, if we question whether this is genuine evidence, we'd have to say no. You can't just accept them as a blanket rule. So the onus is on the provider to make sure that it's genuine evidence for not reporting a student who's below 80%. And remembering that you're obligated, regardless of circumstance, to report any student who's below 70%. The other thing in this area that I see as problematic is the understanding of what happens when you report a student in prisons and make a variation in their COE. You're not cancelling their visa. That's the role of immigration, to decide whether or not the student's visa should be cancelled. It's a whole separate thing. And if you look through the documentation and the advice here, providers are encouraged to maintain a student's enrolment unless they're told to do otherwise. So unless you receive directions from the government department to end a student's enrolment, there's no reason to stop a student's enrolment and eject from the college for poor attendees. There are other reasons why you should, but going below 80% attendance isn't necessarily one of those. But I'd encourage you to look closely at the documentation there. Can't really cover it in depth today. A related one is post-completion reporting. So a while back, the rules changed here. Just because a student's finished doesn't mean that you don't report them. So, a common occurrence in CRICOS is a student with weak attendance who doesn't attend for their last couple of weeks, and their attendance percentage overall plummets, and suddenly they're below 70%. But the provider's thinking, well, the student's finished, there's no point in reporting them. Actually, the requirements are that you do report them regardless of whether or not they've ceased to be a student at your college. So again, that's something that providers should be looking at. A last really simple one is around addresses. Most providers are aware that they have to get a student's address in Australia, and they do it. And most providers do tell students that they're required to update the college if their address changes, and they've got to do that within 7 days. But what a lot of colleges neglect or aren't aware of is that you're also required to update addresses at least every 6 months. That means the college is obligated to go to the students and confirm in writing that the student's address is current and accurate. And that has to happen at least every 6 months. So if you haven't done that lately, that's one to look at. Last few to consider here, a little bit more complicated refund policies. Do check that specifications on calculating refund. There are very specific rules. I very, in fact, almost always see in terms and conditions lines like the enrollment fee is non-refundable. Not strictly speaking compliant all of the time. There are a number of cases where that is not compliant and where you shouldn't be keeping that fee or not the full amount. And if you look at that calculation of refund legislation, you'll see that there are very specific rules around how much you can keep and under what circumstances you can keep it. And when you need to pay things in terms of timing and who you need to pay. So you know they're really quite specific in this area at least. A more perhaps nebulous area is this clause in the CRICOS standards, which basically says that ASCA or TEXA can kind of require any kind of business management document that is reasonable to request. Excuse me. And some of the most common ones that they do request quite reasonably are strategic planning documents, you know, annual business plans and so on, financial modeling and financial statements, and that can generally go for those who are under ASCA into the financial viability risk assessment tool, which is a pretty complicated 6-page Excel spreadsheet that you've got to populate. It can be really challenging. And another one is governance. Now, the issue here isn't, in my view, that most providers aren't up to date with these things. The issue is that getting up to date with them can take a solid chunk of time. In fact, that financial viability risk assessment tool is really complex. I worked with a client who had a pretty sophisticated financial team. They had a CFO who was a very sophisticated, very smart, very competent individual, but it was the first time he'd ever seen it, and it requires a little bit of inside knowledge, I guess, in how to do it effectively, and it also sort of crosses many boundaries. Seen providers have issues with the regulator when the information that they submitted all seemed fine, but the marketing team, the admissions team, the academic team and the finance team hadn't really coordinated effectively enough. That was clear from the financial modeling, where fees in one were different to another, and it all sort of unraveled from there. And so, making sure you're coordinated across these things can take a lot of time, and often you don't get a lot of time. And when you've been given a month to put in a submission, and you're doing your normal job and maybe other projects, and you're doing a whole swathe of things for a submission to the regulator, often this can just be that one step too far, or it could just lead to a pretty agonizing month of all-nighters just to try and get everything done in time, and those all-nighters tend to lead to mistakes. So these are all areas that the colleges, especially the executive leadership, really should be looking to have up to date regularly. Another common one I see is other uses of premises. And the CRICOS standards has requirements here that you've got to have a policy and procedure to make sure that anyone else using the premises, whether it's you share some space with a vet provider or whatever it might be, maybe you've got a tourism operation in the facilities, but those things need to be part of a policy and procedure for how you will ensure that students are safe around those things. So, look, this is I guess a fairly long list in the end, but these are the most common things I see go wrong with colleges. You know, there's an enormous amount of detail in doing all of these things, and they're very often missed. Another really common issue is where, and especially in bigger organizations, where one person thinks that the other person is taking care of it, and that person thinks that someone else is taking care of it, and in the end, no one is taking care of it. You know, this is a really big problem, and again, you know, some helpful questions that can help you avoid this one is when you notice things, is to really ask, you know, who is looking after this issue, whatever that issue might be? Who's looking after our agent contracts? Who's looking after ensuring that our refund policy is fully compliant? And when you know who, then ask them, how is it being looked after? What steps are being taken? And when were they taken? And when will it be complete? And when are we sure? And how will we be sure? You know, so those are really important questions to ask, and to actually, you know, get some conscious, what's the word? Some awareness, you know, where it's actually verbalized or written down that someone has committed to it. You need a commitment. That's the word I was looking for, commitment. You need a commitment to responsibility and accountability on these things. Wouldn't be a talk about compliance if we didn't talk about policies and procedures. You know, most of the time when I ask colleges during a compliance review, you know, what policies and procedures have you got? Can you show them to me? They go scrabbling around through their folders on their computer, or they'll go looking for some ring binder that they dust off. Really, if policies and procedures aren't live documents, if you're not referring to them regularly, if people aren't reading them when they come on to new jobs, then they're just not relevant. They're not meaningful at all. Policies and procedures should be you know, real documents. And I think I'm running out of time, but my view is that they also should be exhaustive. If you look through the National Code, for example, you'll notice that only about half of it requires a documented policy and procedure. I think that's a recipe for disaster personally, in that if there are rules that you've got to follow and you don't have a manual for following those rules and how you will do it and when you'll do it, who will do it, then it's a bit of a recipe for not doing it. So I would encourage colleges to have a fairly exhaustive set of procedures to cover everything. So just finishing up, the last thing I'd say is, you know, that something I see again and again is colleges telling me that, you know, oh, we passed our last registration just fine, so surely there are no issues. That's rarely the case. You know, we have to recognise that the regulator is churning through literally thousands of colleges in the ELICOS/VET space of ASQA, and hundreds of very, very large institutions in Texas respect. And so they have to take a risk management approach, and they can't look at absolutely everything. But as I've seen in a few instances, they may not miss it next time. Things may happen that, you know, lead to them looking again and noticing things. And I've seen cases where providers are a little bit miffed because what passed last time didn't pass this time. You know, it's hard to make the argument that, well, you didn't say I was non-compliant last time, so you can't this time. You were non-compliant the whole time, just that you didn't get caught. So, you know, just be very cautious around assuming that just because you got through last time, you'll get through next time. I recently did a review for a college where they had the regulator through a month earlier, and I actually uncovered pretty major non-compliances that that they needed to fix and change in the way they operated, that the regulator had missed. I don't know if that's a controversial statement, I'm getting myself in trouble here, but it's the reality of things that that things get missed, but they may not get missed next time. So just being ever vigilant, I guess, and continually looking. Right, and I guess as a last thing, I think there's been a few questions along the way. So maybe I can take a moment to look through those. Just give me 1 minute.
There's one there. And if you could read it out to everyone.
In regards to genuine evidence, we won't accept certificates that are backdated from chemists. Is that correct? Yeah, look, there are no specific requirements, and if you look at a lot of the different bits and pieces in the Act and in the regulations and in the standards and so on, they're kind of high level, is the government's view, and the reason for that is that they're giving you the benefit of the doubt that you can interpret them appropriately. Now it says genuine evidence, and realistically what they're saying is that would a reasonable person in reasonable circumstances treat this as genuine evidence? I think your position is perfectly reasonable. If it's a backdated statement, I probably would question it too. To some extent, there's a case-by-case basis. If you've got a student walking in and they're on crutches with a broken leg and their doctor's certificate was signed after the hospital visit, then you can probably give them the benefit of the doubt that it's a genuine certificate and a genuine reason. Other times, I saw one recently where the doctor's certificate were literally said, Mr. X told me that he was sick and couldn't go to school, so please excuse him for a month. And obviously that's not genuine evidence. It's questionable in terms of professionalism to write a certificate like that, but it happens. So look, I would just take a sensible approach. Possibly wouldn't take a blanket approach, but a sensible approach to deciding what's genuine evidence. And I think you can all manage that one. How much accuracy is required in terms of contact information such as address? Student often put the address of the agency's workplace address. Okay. There are two obligations here. One is on the student and one is on the college. The student is required to give you and update you with their residential address, their phone number, and their email. Their agent's address is probably not where they're sleeping. So it's not enough. I had a provider recently ask me if what they should do when their students don't have an address because they're sleeping in a car. I would suggest that immigration would not look fondly on the fact that the student can't afford rent and is without an abode, and I'm not sure if that is an infringement on some other aspect of their student visa. But look, you should have an accurate residential address. You would be obligated, I would suggest, to make a reasonable effort to ensure that that's accurate. A reasonable effort would be to say to the student, is this where you live? I think that the students are perfectly capable of lying to you, and then they're failing their obligations according to their student visa to update you. Do you need to check bills and so on? I think that's probably taking it a step too far to expect providers to do that. I'm not the regulator though, so I can't really say. But I think generally speaking, as long as you take reasonable steps, that's probably sufficient. Is there any?
That's it for questions for now, but a few more might come through.
Okay.
Yep.
I think that's the only questions
So
we have so far.
Yep.
If anyone has any others. All right. So I don't see any other questions popping up. So I think I'll hand you back to Sophie. So thank you to everyone for your time and for your interest. If anyone would like to contact me to discuss CRICOS compliance or to discuss anything relating to your college, you can see my contact details there at ieinitiatives.com. Feel free to do so. All right. Well, is this a little bit? I'll pass you to Sophie to answer this question. All right.
great. So thank you very much, Ian, for coming to present to us today. It's really informative. There's a few questions about the recording of the webinar. The webinar has been recorded. We'll send people a link to access that recording and the slides tomorrow to your email addresses. And you can also access a statement of attendance for this session through the LTAR, which is on the English Australia website. Again, instructions for how to download your certificate of attendance will be emailed to you. So again, thank you, Ian, and thank you to everyone for coming. See you.